Thank you. Thank you very much for having me here today. My name is Colette Rutel, and I'm the professor and co-director of the Native American Law and Sovereignty Institute at Mitchell-Hamlin School of Law. I've taught at Mitchell-Hamlin or its predecessor, one of its predecessor schools, since about 2009. And before that, I was in private practice at Faegre and Benson, back when it was called that, and two Indian law boutique firms in town, one of which I'm still associated with as of counsel, Hogan Adams. And I'm here today to talk with you about a really important U.S. Supreme Court decision that was handed down in July called McGirt versus Oklahoma. And I'm hoping to give you some background on that case and then talk about the potential implications that it has for Minnesota. So what is the McGirt case about? And I think probably for this CLE today, there are some of you on this call that have a lot of familiarity with federal Indian law and are very familiar with the McGirt case, and others that don't. So I want to make sure that we start pretty basic, especially because there's been so much misinformation about this case in the media. I've included two of the big headlines from the Washington Post, for example, that made it appear as though the McGirt case was about returning land to Native American hands in the state of Oklahoma. And that's not what the McGirt case is about at all. No land ownership will change hands as a result of the McGirt decision. Instead, McGirt is about jurisdiction. And in particular, it's about whether the Creek Nations Reservation, which was created under an 1832 and 1833 treaty, whether that reservation still exists today. So before we can sort of get into the case itself, it's important to provide a little bit of background if you're not familiar with how land ownership and Indian country works. So I have very basic knowledge of PowerPoints. You're gonna have to forgive the juvenile graphics here, but when Indian reservations in general were initially created, it was often true that they were a contiguous or a mostly contiguous block of what we call trust land. And when we say trust land, the title to this land was held by the United States, but it was held in trust for the benefit of an Indian tribe. And so all of the land within Indian reservations, for the most part, was held originally by the United States for the benefit of the tribe. And I say for the most part because, you know, sometimes you have school lands or swamp lands or other types of land grants that occurred prior to the creation of an Indian reservation. And so it certainly was possible for there to have mixed ownership of land within reservation boundaries, even when it was initially created. But for simplicity's sake, we're going to operate with this kind of orange block of land as being an Indian reservation, all held in trust by the United States for the benefit of tribes. Well, what happened then in the late 1800s to the early 1900s was the federal government pursued this policy known as allotment. And the idea behind allotment, unfortunately, was to break up Indian reservation land bases as an attempt to assimilate Native people into the United States. The idea was that if you force tribal members to farm their land as individuals and hold land individually, that they would eventually abandon their tribal relationship and just become United States citizens. So this policy of allotment wasn't pursued on every reservation. As some of you might know, the Red Lake Reservation in Minnesota was never allotted. But it was pursued on many reservations throughout the United States, perhaps the majority of reservations. So what was once an area of contiguous trust land, when it was allotted by Congress, individual parcels of about 160 acres were given to tribal members. And these allotments were held in trust for a period of time, usually around 25 years. And at the end of that period of time, they could be sold to anyone. And so they could either remain in Indian hands or be sold to non-Indians at the end of the trust period, because the individual tribal member then would get title to the property in fee simple absolute. In addition to these allotted lands, an important piece of most allotment legislation was that the so-called surplus land, or land that was left over within the reservation after all the allotments had been issued, that surplus land was sold off to non-Indians. And so the question that remains after this allotment process has occurred is, does the reservation boundary still exist? Congress first defined Indian country, which is the area over which tribes have the authority or jurisdiction, as all land within the limits of an Indian reservation. And that's true regardless of how that land is held. So regardless of whether it's held in trust or in fee simple, and regardless of who holds the land. So regardless of whether it's held by the tribe, by individual tribal members, or by non-Indians. This definition is in the federal code in 18 U.S.C. 1151. It technically only applies, the way the statute is phrased, it only applies to criminal prosecutions by the federal government. But the U.S. Supreme Court has said that this is the general definition for Indian country. And it's not surprising that this is the definition if you think about the area that Minnesota has jurisdiction or authority over. It has authority within the boundaries of the state of Minnesota, and the state itself does not own most of the land. The land within the state could be owned by the federal government, could be owned by the state, it could be owned by private individuals, and some of those individuals are Minnesota state residents, and some of them are residents of other states, and some of them may even be residents of foreign countries. So one of the things that the Supreme Court has grappled with over the years is whether allotting land, given this definition of Indian country, whether the allotment and sale of land keeps reservation boundaries intact. If it does keep reservation boundaries intact, then all of the land within the Indian reservation is considered to be within the tribe's jurisdiction, regardless of who owns it, and regardless of how title is held. If allotment eliminated the boundaries of the reservation, then the only land that the tribe has jurisdiction over is land that is still held in trust by the United States for the benefit of the tribe or a tribal member. That trust land would be considered either dependent communities or Indian allotments under the federal statute. So there's a pretty significant difference based on whether the allotment statute is read to eliminate reservation boundaries or retain reservation boundaries. In figuring this out, the US Supreme Court created this three-pronged test to determine whether an allotment statute was going to disestablish a reservation, so eliminate reservation boundaries. The court has always been consistent that it's only Congress that can disestablish a reservation. And the reason for that typically is Congress has plenary power over Indian affairs. And most reservations, not all, but most reservations were created by a treaty between the United States and Indian tribes. And treaties can't be altered by any entity other than by Congress. So only Congress can disestablish a reservation. So you are looking for a statute, an allotment statute or another statute that eliminates the boundaries of the reservation. And the Supreme Court said in Solem versus Bartlett, which is a very famous case from 1984, that it's going to look at the language of the statute, the legislative history, and then events after the passage of the statute, such as who is exercising jurisdiction and the demographics. So the Solem test that was created starts with the statutory language, as you would expect. You're trying to figure out if Congress disestablished a reservation, and so you need to see what Congress said in the statute. As an initial starting point, it can be frustrating that when you read these statutes, Congress very rarely mentions reservation boundaries itself. So you're usually trying to read the statute and look at other language because Congress very rarely mentions whether it is disestablishing a reservation. That actually wasn't a term of art at the time most of these statutes were being passed. And I should say, if you have questions at any point in time, feel free to put them in the chat. Hopefully I will see them and be able to respond to them. But if not, I'm sure I'll be interrupted, and I'm happy to answer them as I go along. So since Congress doesn't use this language or wasn't using this language in the late 1800s about eliminating reservation boundaries or disestablishing the reservation, the Supreme Court has looked to the statutes and said, Well, if they include language about ceding land for a set amount, so for example, the tribe is ceding 1 million acres of its reservation for $1 million. The court has said that there's a strong presumption that that language means that Congress meant to disestablish the reservation. The reason for that, according to the court, is that the language cede or cession is about more than just a change in land ownership. It's about changing jurisdiction, if you were to look at sort of the Black's Law Dictionary definition. And so it's evidence that Congress meant for jurisdiction to change when the land was sold, and not merely the ownership of the land. And by providing a flat fee or a certain sum for the land, we can point to one moment in time when the reservation was disestablished, which is very important because this will change jurisdiction, which parties, which sovereigns have the ability to prosecute crimes, which sovereigns have the ability to tax, which sovereigns have the ability to hear civil adjudicatory lawsuits. So there's this cede plus some certain language that the court is usually looking for. The Supreme Court has distinguished that from the statutes that just talk about selling off land and that offer to pay the tribe a certain amount of money per acre. So paying, for example, $1.20 per acre and selling off all of the surplus land. If you note, both of these different, sort of this statutory language is really focusing in on the surplus land itself and not allotments, because the Supreme Court has generally said that when an allotment was given to a tribal member, there really isn't evidence that Congress intended that action to disestablish a reservation, because whether or not it remained in Indian hands was really subject to the whim of the tribal member who held that land, whether they decided to sell it or not. And you can't point to one particular point in time then as a result when the reservation would be diminished or disestablished. In addition to that factor about statutory language, the Supreme Court has generally looked at legislative history. And this is a little bit broader than legislative history in other areas, because a lot of times the executive branch was negotiating allotment with tribes, negotiating an agreement with them that was then taken to Congress and passed as a statute. So the court will look at those negotiations in addition to traditional legislative history and try to see, was there any discussion of reservation boundaries or jurisdiction when the parties were discussing the allotment and sale of surplus lands. The last, prong that the court created in this test dealt with subsequent events. And the court said that it would look to see who exercised jurisdiction in the area following the Allotment Act. Was it the federal government, state government, or tribal government? What, if anything, did Congress say? Did Congress pass additional statutes that later referenced the reservation, which would lead you to believe that perhaps the reservation wasn't disestablished? And the court also said it would look to demographics. So what is the population within the reservation? Is it predominantly Indian or non-Indian? And who owns the land within reservation boundaries? It's this third prong that has been fairly interesting for practitioners in this area, because the Supreme Court normally says that post-enactment history is basically worthless. That the actions of subsequent Congresses, for example, shouldn't be used to determine the intent of a prior Congress, and let alone the actions of completely different parties. So, for example, whether the state decided to exercise jurisdiction within reservation boundaries, whether individual non-Indians decided to purchase land. This is not something we would normally look at outside of Indian law and outside of this sort of unique context of reservation disestablishment cases. The court acknowledged this when it was creating this prong to the text. It said, resort to this subsequent demographic history is unorthodox. But claimed that it was still necessary to try to go back and figure out what Congress's intent originally was when it passed the Allotment Act. Eventually, though, it seems to have reconsidered this third prong. And in Nebraska versus Parker, which is a fairly recent U.S. Supreme Court case decided a few years before McGirt, the Supreme Court clarified that it has never relied solely on this third prong. So it's never relied on just what has happened in terms of jurisdictional history and demographics to decide that a reservation was diminished or disestablished. And that evidence can be used to support the court's findings based on the first and second prong, but can't be used in absence of evidence of disestablishment in those two prongs. Okay, so this test has been settled case law for a long time. As you can see, there are at least 8 Supreme Court decisions that have articulated the test and applied it in recent years with very little change. And so that takes us to McGirt then, which was about the Creek Reservation. And this slide has a map of the Creek Reservation. The reservation was created by 1832 and 1833 treaties. And the Creek Nation, in signing the 1832 treaty, was agreeing to remove from lands in Alabama and Georgia and travel into what is today Oklahoma. It was then called the Indian Territory, and change their permanent homeland to that location. What is really interesting about the history here is that unlike other reservations that I talked about, the land was not held in trust by the United States for the benefit of the tribe. And that's because the Creek Nation requested fee land. The Creek Nation was in a rather unique position in the 1830s. There were a number of tribal members that could actually read and write and speak in English. And we're familiar not only with the English language, but also with Western legal concepts and land ownership. And so from the Creek Nation's perspective at the time, it seemed as though, and it's unlikely they had a full understanding of the legal structure of property ownership, but it was understood at the time that fee simple was going to give them more rights to the land than having the United States hold the land in trust. And you see this as tribes throughout the United States, as tribal members over time start to figure out what the U.S. legal system is in terms of property ownership. You see more and more tribes that are requesting fee simple ownership because from their perspective, white people or white citizens don't lose their land, and it's only Indian land that's taken away. And so they want the same type of land ownership that white citizens have. And that's what the Creek Nation is asking for here, and that is what the United States gave them. So the treaty sets borders for the Creek Nation and refers to it as their permanent home, and it promises in those early treaties that they'll have complete sovereignty over the area, and reaffirms that later on in 1856, says that they'll never be part of any territory or state. They'll have full jurisdiction over their members and their property, and the right to self-government. So what happens then in the late 1800s is, in accordance with general federal policy at the time, the federal government wants to allot the Creek Reservation. And Congress actually directs the executive branch to send out negotiators to negotiate with Creek Nation to get an allotment of the reservation and sell off the surplus lands. But the nation refuses to allow for any sale or cession of surplus lands. And so that's abandoned for a number of years. It's not until 1901 that the Creek Nation and the United States enter into an agreement, and the agreement provides for all of the land within the Creek Reservation to be allotted to tribal members. And it was going to be inalienable for a period of time, and then it could be sold after that. But the important provision here is that there was no surplus land sale that was agreed to by the Creek Nation, and there's nothing about a surplus land sale in the allotment statute. And so this is different from the other statutes that the Supreme Court looked at in creating the Solem test. Because there's no surplus land sale, you're not going to see any of the statutory language that the Supreme Court normally looks for. So there's no cession language. There is no some certain payment. there's no date that you can really point to unless you point to the Allotment Act itself, passed in 1901. There's no date you can point to other than that for when the reservation might have been disestablished. But of course, in 1901, all of the land was still in Indian ownership and remained in Indian ownership for some time. So there's also no evidence in the negotiations that there was any intention to change reservation boundaries. So what are Oklahoma's arguments in this case? Oklahoma was arguing that the Creek Reservation boundaries no longer existed. And the primary argument that Oklahoma was making was that they've ignored the boundaries of the Creek Reservation and that everybody has agreed that the boundaries don't exist anymore for the past 100 years. That was the primary argument relied on by the state, was that they had been exercising jurisdiction, and in this particular case, they were talking about criminal jurisdiction over the reservation for more than 100 years. And they pointed out that the federal government rarely prosecuted individuals in the area, and that modern demographics were overwhelmingly non-Indian, both in terms of the population as well as the land ownership. So in other words, they were arguing that despite what the Supreme Court had recently said in Nebraska versus Parker, that the third prong of the Solem test should control if it was going to be applied. Obviously, that's a pretty weak argument. So the state of Oklahoma was primarily arguing that the court should not apply the Solem test here, and had a number of different reasons for why Solem shouldn't be applied. First, they said that there was never a Creek Reservation, and this was raised for the first time in the U.S. Supreme Court. They claimed that that the treaties don't use the term reservation, and that it shouldn't be considered a reservation because it was provided to the Creek Nation as fee land, not trust land. And there were other things that the state said which made it look not like an Indian reservation. Creek tribal members weren't required to stay within the boundaries of the reservation historically. They pointed out that there wasn't always an Indian agent assigned to the reservation, et cetera. So they were trying to argue that the Creek Reservation never existed. In addition, they also made an argument that one way to disestablish a reservation that has never been acknowledged before, was a new argument, was that Congress could disestablish a reservation by limiting or eliminating tribal sovereignty. And so if Congress took steps in a statute to limit tribal sovereignty or eliminate tribal sovereignty, maybe that affected the existence of the reservation. So Oklahoma pointed out statutory provisions that abolished the Creek court system, that required the president to approve Creek ordinances, and Congress passed a statute that anticipated that the Creek Nation would be entirely terminated before it reversed course, and it never went through with that provision. So this case was very nerve-wracking, I would say, for Indian law practitioners, because the test was pretty solid and had been established in 8 prior cases, as I noted, and now here's Oklahoma pointing out that they've exercised jurisdiction over this area for 100 years and acted as though the reservation hasn't existed, and arguing that the test should be modified. And so no one was exactly sure, would if the Supreme Court upheld the existence of the Creek Reservation, it was going to have rather profound effects on the ground in Oklahoma. There's no way to argue differently. And so if the Supreme Court wanted to avoid that, everybody was quite concerned about not only what the impact would be in this case, but how it was going to change this test for reservation and disestablishment, and how that might affect tribes throughout the United States. The other reasons why Indian law practitioners were really concerned about this is because the case reached the Supreme Court through a criminal prosecution. And so the Creek Nation itself wasn't even a formal party. They participated as amicus, and fortunately the US Supreme Court did grant them the ability to argue during oral argument as amicus. And this is a picture actually of Riaz Kanji, one of the really exciting things for me about this case was Riaz was my mentor throughout law school. He was an adjunct professor at the University of Michigan when I was a law school student then, and we've remained in close contact since then. And he argued this case on behalf of the Creek Nation in the U.S. Supreme Court. This case and its sister case, Carpenter versus Murphy, were the first cases that he's argued in front of the U.S. Supreme Court. So it was really exciting for me to be able to participate in the case, representing National Congress of American Indians as an amicus, and be able to see, one of my very close mentors argue in front of the U.S. Supreme Court. In addition to these things, I think practitioners were also very nervous that there was a very limited historical record, again, because it was a criminal case. Usually these reservation disestablishment cases, the tribe is the party, the state or local governments on the other side, you're developing the historical record through expert witnesses, you have historians and linguists, and none of that really happened in the case because of the way it was presented. There was some historical evidence that was submitted through the appellate process, but pretty limited. And most of the parties were, as a result, relying on secondary sources and statutes and legislative history, and not the full legislative record, and not the full historical record that you would normally see in these cases. So imagine our excitement when the Supreme Court decided in a 5-4 decision in July that the Creek Reservation still remained intact. And so, again, this isn't surprising. The outcome isn't surprising from the standpoint of what the existing legal structure was. But it was surprising from the standpoint of the implications that the decision had. The case, the majority opinion was authored by Justice Gorsuch, but it was a 5-4 decision. So one of the things about this opinion, and I'm going to do what they tell you never to do in PowerPoint, a bunch of slides here that are large block quotes, and I apologize for that. It's just that as Indian law practitioners, this has some of the best language of any U.S. Supreme Court opinion. It's something that is already being quoted again and again when you look at appellate briefs that are being filed, and both inside of the field of federal Indian law and outside. The tone of the opinion is, of Justice Gorsuch's opinion, is one of trying to hold the United States to its word, as you can see here, to its promises, unless Congress specifically states otherwise. And the language of the court throughout the opinion, really backs that up, that the court is not going to bail Congress out here. If Congress wants to disestablish the reservation due to the implications, what could happen to criminal jurisdiction or civil jurisdiction, Congress is going to have to do it itself. The court's not going to do that when the language of the statute doesn't authorize it. This opinion, I guess, is in many ways it's not surprising for Indian law practitioners that Gorsuch wrote it, although I think it is surprising for people outside of the field of Indian law. Justice Gorsuch is an originalist in terms of his interpretation of the Constitution, and the way he interprets treaties is the way the U.S. Supreme Court generally does, according to the original meaning construed, just looking at the intent of the tribal negotiators. So he has a very, broad reading of Indian treaties as a result. And when it comes to statutes, in this case, he's focusing on the text of the statute. And talks about what's important to figure out is the original meaning of the law. So what did Congress intend when it passed this Allotment Act in the early 1900s? And the modern day implications of that are something that he says the court should not consider. And he says pretty explicitly that there's no need to consult these other sources when the terms of the statute are clear. Language that has been quoted a lot already in court decisions, as well as in briefs, both inside and outside of federal Indian law, is this notion that just because a legal wrong has occurred for a long time, or is, could have, changing it could have substantial effects, doesn't mean you should continue to perpetrate it. So I want to now talk a little bit about the implications of McGirt. That's basically the overview of the decision itself. The decision is pretty new still. I mean, it was handed down in July of this year, but it has already impacted a few reservation boundary cases that have been decided. So there's a case called United States versus Smith, which comes out of the U.S. District Court in New Mexico. And it was looking at one of the pueblos in New Mexico and trying to figure out whether the Pueblo Land Act in the 1920s had disestablished the boundaries of the Pueblo reservation. And the court said no. The court found that there was no diminishment or disestablishment of the boundaries of the reservation, and cited McGirt for the proposition that when you're looking to something other than the text of the statute, in particular when you're looking at something that happened after Congress passed the statute, so which parties exercise jurisdiction, for example, or what the demographics are, you can only look to that information if there's ambiguity in the statute and if you're trying to clear up that ambiguity, not create it. Closer to home, there was a decision already from the U.S. Court of Appeal to the Seventh Circuit. And this case involved the Oneida Nation of Wisconsin versus the village of Hobart. So this is in the Green Bay area of Wisconsin. And the Oneida Nation had brought the suit for declaratory injunctive relief, asking the court to declare that its reservation boundaries still remained intact. They were having a dispute with the village of Hobart about a number of things, but in particular, this case was about which sovereign had the right to regulate their Big Apple Festival. And the United Nations said, hey, this is our authority because you're within reservation boundaries. The district court ruled against the United Nation, and the Seventh Circuit reversed in a pretty strong opinion. The court noted actually that it didn't need McGirt, that the case should be reversed under the Solem test. The district court just applied that test incorrectly. But the important language here, which I have on the slide, is that the Seventh Circuit says McGirt really adjusted the Solem framework to place the emphasis on the statutory text. In some ways, eliminating the other two prongs of the test, and that's it's a tighter test than the Solem test. There are a number of pending cases where McGirt is already being used. It's already been used extensively in the briefing, and these are reservation boundary cases as well. A case involving the Little Traverse Bay Band in Michigan, in the upper part of the lower peninsula of Michigan. The Little Traverse Band lost at the district court stage on summary judgment, and they've appealed that to the Sixth Circuit. And it's being, at the Sixth Circuit, it's being litigated by Riaz Kanji again, who argued the case in McGirt for the Creek Nation. Little Traverse had lost below on reservation creation. Basically, the state of Michigan was using a lot of the same arguments that Oklahoma used for the first time in the U.S. Supreme Court that were rejected in the McGirt case. And so McGirt likely is going to be a substantial factor in that reservation boundary case. There's also a case pending that involves a section of the Yakima Reservation in Washington State, and that's set for oral argument here later on this month. And then there's a case involving the Penobscot in Maine that's got a really technical question about whether the reservation in a particular location includes only the islands or the waters around the islands. I think McGirt will probably be less relevant to that case than it is to Little Traverse and the Yakima case. And there's a number of other reservation boundary cases pending. These are just the ones where McGirt has already been extensively used during briefing and in some cases oral argument. In terms of the impacts in Oklahoma, and when I'm looking down, I have a little timer on myself to make sure that I am staying on point so we can get to the impacts in Minnesota and so I can hear any questions that you have about this topic. But when it comes to the impact of McGirt, you know, it's one thing to start with by talking about here are the other cases where reservation boundaries are being adjudicated, but that doesn't mean much if you don't know what the recognition of reservation boundary does in terms of jurisdiction. So in McGirt, the court recognized the continuing existence of the boundaries of the Creek Nation. And if you remember that earlier slide, it's a pretty massive reservation in the state of Oklahoma. And one of the things that was pointed out in briefing by the state of Oklahoma is the facts that the Creek Nation had are very similar to the facts of other tribes in Oklahoma. That is, both the treaties the Creek Nation had, as well as the allotment statute, is very similar to what you see for the Cherokee Nation, for the Chickasaw Nation, for Choctaw. So the McGirt decision will likely have a very direct impact on large sections of land in Oklahoma, and they were anticipating, you know, even just for the Creek Nation, we're talking about maybe 1.8 million people. So what are those impacts? When it comes to criminal jurisdiction, the recognition of a reservation, meaning it's Indian country, for the most part, the default rules would mean that Indian defendants, whether they're members of the Creek Nation or members of other federally recognized tribes, would be prosecuted by the federal government or the tribal government or both. They wouldn't be prosecuted by the state government. And so following the decision in McGirt, what we've seen is a lot of motions to dismiss that are being filed for cases that are pending against Indian defendants, not only within the Creek reservation boundaries, but elsewhere in Oklahoma and within the boundaries of Cherokee, Chickasaw, Choctaw, et cetera, reservations. And those cases then will be prosecuted or will need to be prosecuted by the federal government and the tribal government. So it has required that the federal government significantly ramp up its prosecutorial. You know, it normally did not prosecute a high volume of cases, and now it does need to prosecute a high volume of cases. And so that's happening right now. In addition to criminal jurisdiction, a lot of the discussion in oral argument in McGirt was actually over the impact it could have on civil jurisdiction. I think the important thing here is that reservation boundaries under U.S. Supreme Court case law that exists now anyways, reservation boundaries primarily impacts tribal members, not non-Indians. And so what I mean by that is that it primarily means that the tribe has jurisdiction over its own tribal members within reservation boundaries, not the state. The state typically doesn't have jurisdiction for civil purposes, but the tribe usually does not have very much jurisdiction over non-Indians within reservation boundaries. And if you're interested in the contours of that, I'm happy to talk about it in questions. So the big areas that we see right now, for example, are cases involving the Indian Child Welfare Act. So if there's an Indian child and there's a child protection case pending, if that child is a Creek citizen or is eligible for citizenship in the Creek Nation, and the child is domiciled within the boundaries of the reservation, it's the tribe that has exclusive authority to hear a child protection case, not the state. So the state court doesn't have jurisdiction over those ICWA cases. Now, interestingly, the Creek Nation pretty quickly entered into an intergovernmental agreement with Oklahoma to allow Oklahoma to keep hearing child protection cases that were pending that involved Creek children. The Creek Nation is working very quickly to try to increase its capacity for hearing these cases, but at the time McGirt was decided, you know, it only had a handful of social workers and obviously really needs to substantially expand that office in order to properly provide services in those cases. So the Creek Nation and the state entered into an intergovernmental agreement to enable the state of Oklahoma to continue to hear those cases while, you know, hopefully it's only temporary, a temporary thing while the Creek Nation is increasing its capacity. In addition to those ICWA cases in the civil side, taxation is likely to be impacted. And again, this involves taxation of tribal members, not really taxation of non-Indians. The tribe will have very, very limited ability to tax non-Indians within reservation boundaries, and its ability to do so will really be tied to what we call a consensual relationship. So if the tribe or a tribal member is selling non-Indians a good, for example, the tribe could impose a sales tax on that transaction. But aside from that, the tribe is not going to have general authority to tax non-Indians within the boundaries of the reservation. It's primarily about limiting the state of Oklahoma's ability to tax tribal members. So now if you're a tribal member and you live and work within the boundaries of the Creek Reservation, you will not have to pay Oklahoma income tax. If you're a tribal member and you purchase goods within the Creek Reservation, then you don't have to pay Oklahoma sales tax. The idea here is because you're within the boundaries of the Creek Nation, it's the Creek Nation that will impose its tax as opposed to the state imposing its tax. And there will likely be alterations to private lawsuits as well too. If you want to sue a member of the Creek Nation, you're primarily bringing that lawsuit in tribal court rather than in state court. So those are the impacts of McGirt, briefly, the impacts of McGirt in Oklahoma. And so what about the impacts here in Minnesota? When it comes to Minnesota, there aren't very many reservation boundary cases where where McGirt is likely to have a direct impact. The exception to that, of course, involves the Mille Lacs Band. So the Mille Lacs Band currently has a lawsuit for declaratory or injunctive relief. And I see that there's a question that just came up in the chat about will it impact or support the M opinion for the Mille Lacs Band, and more broadly claim that the reservation is still intact, and will you see a Supreme Court case on this? It's definitely relevant. The question is definitely relevant to what we're talking about here. So when it comes to the Mille Lacs Band and when we're talking about the M opinion, the Mille Lacs Band, some of you may know that we're in what's called a public law 280 state in Minnesota. So normally, when I was talking about criminal jurisdiction in Oklahoma, normally state does not have the authority to do prosecutions within Indian country. But Congress altered those rules in Minnesota through a statute called Public Law 280 and gave the state the ability to prosecute certain crimes within Indian country under Public Law 280. So the state's been engaged in prosecutions on the Mille Lacs Reservation and a number of other reservations in the state of Minnesota. When Congress passed the statute called the Tribal Law and Order Act, that enabled tribes in Public Law 280 jurisdictions to ask the federal government to also come back and do prosecutions within Indian country. And those had ceased when Public Law 280 was adopted. The federal government was invited back by the Mille Lacs Band. Mille Lacs Band asked the federal government to do prosecutions because it believed that the state was not adequately prosecuting particularly non-Indians within reservation boundaries for crimes that were committed. And the federal government agreed to do those prosecutions. The M opinion that is referred to in the chat, when the federal government decided that it was going to go ahead and do some of these prosecutions, it had to determine under what area was it going to exercise authority. So what were the boundaries of the Mille Lacs Reservation? Did the Mille Lacs Reservation still exist? And if so, what were the boundaries? And so it issued an M opinion. Again, it's not a binding opinion, but it's an opinion that the solicitor's office issued that indicated that the federal government believes the boundaries of the Mille Lacs Reservation, as established by a treaty, are still intact. So the federal government supports the tribe's position that its reservation boundaries are still intact, and the state does as well too. Now, earlier this year, the state indicated that it was not supporting the county in the lawsuit, that it believed the reservation boundaries were still intact. McGirt will definitely, I think, assist the tribe in this case, because the argument that was being advanced, or was likely to be advanced by the county, was largely about the modern day demographics and who was exercising jurisdiction within reservation boundaries. So it was likely to rely, and I say likely because, you know, they're just wrapping up discovery, I believe. So we're before summary judgment briefing, certainly before trial, so before the arguments are really fleshed out by the parties. But the case on the county side was likely to rely pretty heavily on the third prong of the Solem test, which now has been called into question whether it's really part of the test at all through McGirt. So I think it will have an impact on the resolution of that case, the McGirt decision. That's the only reservation boundary case that's out there in Minnesota. There's another question about the fact that one of the arguments Oklahoma made was that thousands of criminal cases would be relitigated in federal courts, and asking whether anything along those lines is happening. Is there any evidence that tribal members convicted in state court are now seeking to have their cases reheard in federal court? There are. I mean, it's too early to make a lot of statements about this, because McGirt was just decided a few months ago. But there are certainly already a series of published decisions, if you look at a small number, where members, for example, of different tribes, outside Creek Reservation, but arguing that the same rules should be applied to Cherokee or for Choctaw or Chickasaw. They are making that. Federal courts are allowing the counsel to be appointed for indigent defendants who have already been convicted, so they can flush these arguments out. Primarily, what will be at issue is whether those arguments are preserved, whether they can be raised now, depending upon where that individual defendant is in their appellate process. Did they already exhaust their state court appeals? Did they already exhaust their habeas route? Those same issues about whether McGirt himself could bring this case in the U.S. Supreme Court, because there were arguments that he had not properly raised this as a defense as a matter of criminal law in his earlier proceedings. The state of Oklahoma decided to waive those potential procedural arguments in the U.S. Supreme Court because they wanted this case decided by the Supreme Court. And I know, in hindsight, you say, well, why did they do that? I mean, but there was a 10th Circuit decision that was favorable to the Creek Nation in terms of recognizing its boundaries. That was in the Carpenter versus Murphy case. Supreme Court granted cert. This was just the term before McGirt, and was split because Justice Gorsuch couldn't sit on that case. He was in the 10th Circuit at the time. It was decided by the 10th Circuit. So he had to recuse himself, and it seemed like the Supreme Court was split 4-4. Which would mean that 10th Circuit decision would stand. So unless there was a change, Oklahoma was already facing the fact that the Creek Nation's boundaries were recognized by federal appellate courts. So it decided to waive those procedural deficiencies. So it's difficult to tell at this point, just because it's so early, how many convictions will end up being overturned, state court convictions, and then how many of those will result in federal prosecutions. I imagine there'll be a number of them that are tossed out due to these procedural issues, but there are a number of pending cases that were immediately dismissed and now are being prosecuted by the federal government and/or the tribe. So in addition to those issues in Oklahoma, in addition to the reservation boundary case in Minnesota, we don't have a ton of time left, but I think one of the things that's important to mention is that this case is a lot broader in terms of its impact in Minnesota, because it is a case about treaty interpretation and treaty abrogation. And I'm not going to have enough time to really address this issue, but one thing that I want to flag for you is that this is just one of 4 cases the court has heard on treaty interpretation or treaty abrogation since Justice Gorsuch joined the court. And so we've had the opportunity to see what his thoughts are in the field of Indian law. And through these cases, which include Washington Department of, I think it's called Licensing versus Cougar Den, a case interpreting the Yakima Treaty of 1855 and the right to travel. There's that decision, as well as Herrera versus Wyoming, and of course McGirt. We see that Justice Gorsuch was adding to a majority of the court in terms of broadly interpreting Indian treaties the way that tribal representatives would have understood them, and requiring really clear evidence on the face of the statute to abrogate treaties. And so that will likely be used, that framework will likely be used by litigants in much broader array of litigation than just reservation boundary cases. So for example, in off-reservation hunting, fishing, gathering cases is just one example. I have to say though that Justice Ginsburg's, unfortunately, her death and the appointment of Justice Barrett now has made us, again, kind of not sure where we are going to stand in terms of treaty interpretation or treaty abrogation. We're going to have to wait to see the first couple of cases that the court decides with Justice Barrett on the court to figure out where the majority of the court lies. There's also a question about asking you to speak about jurisdiction over non-Indians and non-Indian people on Indian land. So when it comes to criminal jurisdiction over non-Indians, tribes under U.S. Supreme Court case law, there's a case called Oliphant versus Suquamish tribe decided in 1978, I think. The Supreme Court decided that tribes did not have criminal jurisdiction over non-Indians. Congress has altered that only slightly through the 2013 amendments to the Violence Against Women's Act. If tribes jump through, there's a number of hurdles within that VAWA statute. If tribes are able to satisfy the criteria and they ask the federal government to be able to do VAWA prosecutions, then they can prosecute non-Indians for domestic violence-related offenses. But that's the only area of criminal jurisdiction. When it comes to civil jurisdiction, on non-Indian fee land, it's clear that the tribe has pretty limited civil authority, and there are 2 exceptions to that. The tribe can regulate or adjudicate cases that involve a consensual relationship between the tribe and a non-Indian. So the easiest example of that is a contract. If you're a non-Indian and you enter into a contract with an Indian tribe, for example, maybe you're constructing a building for the tribe on the reservation, then the tribe would have jurisdiction to have the courts hear a breach of contract action. And the parties, of course, can negotiate around that if they want to through a choice of forum provision in the contract. But if they don't, the tribe likely has adjudicatory jurisdiction to hear a breach of contract actions. That's one example. Marriage, dissolution of marriage is another example of a consensual relationship. So between a tribal member and a non-Indian, if you're seeking a divorce action, then that's probably something that can be heard in tribal court. The other category of cases that tribes have authority over when it comes to non-Indians are cases that seriously impact the tribe's political integrity, health, safety, or welfare. And the Supreme Court and lower federal courts have interpreted this pretty narrowly. It has to be quite a significant impact to the tribe for the tribe to be able to exercise jurisdiction over a non-Indian. So for example, a tribe is unlikely to have jurisdiction to be able to enforce a zoning ordinance against a non-Indian who owns property on the reservation. And the exception to that might be is if you are, doing like dynamite operations on your land and it's in an area that is of extreme, cultural and religious significance to the tribe, they might be able to argue under that second Montana exception that they have jurisdiction over that activity because it so seriously imperils the health, safety, or welfare of the tribe. But it's a pretty narrow category of cases. The question that Liz asks specifically about what about on Indian land is a little bit more up in the air. I mean, the Eighth Circuit has been applying that test that I talked about, consensual relationships or serious impact on political integrity, health, safety, or welfare, has been applying that on Indian-owned and non-Indian-owned land. But I think that is likely to be the subject of future cases. The Supreme Court was about ready to address that in a case called Dollar General that was in front of the U.S. Supreme Court, but Justice Scalia passed away when that case was pending, and the court was split 4-4, and so we didn't get a Supreme Court decision on that particular issue. So I think we're almost right up. It's 12:56. Is there any last questions that you have that you'd like to ask? In addition, I'd say, on the impact of McGirt, obviously, this case gives you an idea of Justice Gorsuch's views of statutory interpretation. But those aren't too different from the conservative wing of the court's views on statutory interpretation outside of Indian law. What's always been unique is that the court has used a very different standard of interpretation of statutes within the field of Indian law and really looked outside the plain language of the statute. If you do have any questions after this presentation, you should feel free to email me. My email is on Mitchell Hamlin's website. I'd be happy to follow up with you. Thank you.
Thank you so much.